difficult getting consensus from a big group when we couldn't really even get a consensus as to what the group said. Don't worry about that. This is really the pointy end of a process, and so to the extent when you're talking about appeals and reviews in particular, what is going to end up at that pointy end is going to be determined to a degree as to the basic planning system. For example, if there's a really tight code or a strategic planning process which eliminates very much discretion, then there may not be appeals from certain decisions. But out of it there came a number of common observations perhaps, and one observation, not in relation to a matter of principle, was that there are some good examples both in Queensland and Victoria about their appeal process and how it operates. And I know that Mr Moore and his colleague are looking at that matter. Public participation and consultation in any appeal or review process remains a fundamental. It was a feature of the 1979 Act, and that remains important. I think there is common ground that there ought to be merit appeals from development applications. A view was expressed that even a minister's decision on a merit review should be subject, on the merits should be subject to an appeal. I'm not sure there wasn't consensus or common ground generally, but at least it was a view expressed by some. There was a general view expressed that an applicant could make an application for rezoning, like a current planning proposal, and that there'd be an appeal from a rezoning application. In terms of merit appeals, we also had to look at the potential tiers and where there is an IHAP, a JREP and a PAC, assuming that they existed. And there was a general consensus that appeals on the merits should still exist even if a decision was made by an IHAP or a JREP or recommended to the decision maker in either case. But in relation to if there was the equivalent of a PAC, which was rigorous in its setup, involved public participation in the determination of its review and other sort of relevant matters of that type, that there would be no merit appeal from a PAC decision. So if as a result of this process, the Minister, in relation to major matters, sent it off to a PAC, which was properly funded and staffed and all the rest of it, then there would not be an appeal from a PAC because it would have the confidence of the public by the way it's set up and the way it operates. There was a disinclination for third-party merit appeals, that is, be it the neighbour who's objecting to the deck next door, which was approved. There was a disinclination to allow that appeal to proceed, basically on the basis that in relation to at least minor matters, there ought to be the certainty of the decision made by the council, and it ought not to be tied up with an appeal on the merits in those minor matters. I don't think there was any disagreement that the general system of appeals by objectors in relation to major matters presently described as designated development should remain. The other side of an appeal process, judicial review or enforcement of environmental laws, it is, I think, the unanimous view that the open standing provisions should remain. That is, any person, regardless of whether they have an interest or are impacted by a breach of environmental law, should remain being entitled to enforce the environmental law or commence judicial review proceedings. In relation to enforcement, a lot of grizzles about PCAs, but acceptance that perhaps that some would have them abolished, some would think they're a terrific system provided when they work well, they really work well. When they don't, they're horrid. There are a multiplicity of acts which deal with environmental offences, and it would be useful if they were all put in one place. Councils are concerned about costs of enforcement, especially when the PCAs have been supervising a project and they get lumped with the problems. Supervising, I mean, in the most general of senses, in relation to the operation of PCAs. Concerns about councils also about their right of entry. This might seem to many a very trite matter, but the reality is if there's some activity going on in residential premises, 20 people living in a two-bedroom apartment, councils are having great difficulty in actually getting access to a residential premises, the operation of warrants and the like, and that there ought to be access, I think, to other information to enable enforcement of what can be a breach which has some significant impacts. There was general consensus that development consents ought not be revoked, other than those presently provided for in the event of fraud and the like, and that where there are conditions of consent that they ought not be changed to catch up with science, that where science has changed generally other legislation, be it the pollution legislation or the fire and safety legislation or OH&S even, will catch up with those changes so that the certainty of a development consent and its conditions ought remain in place. Right? Thank you.
Nothing to add.